Hello everybody, my name is Sarah Lollar. Happy Friday to all of you. I'm an immigration attorney here at Gardner and Mendoza in Virginia Beach. I know that usually you guys get your immigration updates from us on Wednesday in English from John and Radlin, but they are taking some time with the family this week, so I have been challenged to do it in English. I have never done one of these in English. I'm always doing them in Spanish, so bear with me here. Just want to give you a couple of updates. Obviously, I'm alone. I don't have anyone to chat with, so it's going to be a little shorter than the long ones you usually get jam-packed with information, but we'll still get some good stuff in here. So today I want to talk a little bit about the public charge rule, fee increases with USCIS, planned furloughs, and some court updates. First, though, I want to just mention briefly about DACA. I know we've heard a lot about DACA in the news recently. I'm sure John and Radlin have been giving you guys updates all about it. And as you may know, the 28th of July, the Department of Homeland Security issued a memo confirming their decision to not accept initial petitions, to only allow people who already have DACA to renew, and also limiting the renewals to a period of 1 year. So if you already had DACA and you're applying for your renewal, usually it's 2 years. This time it's only the 1 year. However, unfortunately, the state of California this week issued an announcement that it's going to be challenging these restrictions in court. So it is planning on taking DHS to trial. We've seen a lot of litigation this year on DACA, so we're going to keep you updated on any new changes. Hopefully we have some positive changes, and we'll just keep you guys updated on those. So going back to public charge, or let me answer this question really quickly, señora Merodillo. Sí están abiertos nuestras oficinas, pero no puede venir simplemente a dejar cosas o pasar. Estamos abiertos, pero no siempre nos encontramos aquí. Entonces, si desea pasar por oficina, por favor, llámenos antes de venir a 757-464-9224. Gracias. So, back to public charge. So February of this year, as you guys may know, finally President Trump announced a new method to measure whether or not an immigrant is likely to become a public charge to the United States. So it's always been a rule. It's just a new type of analysis. It's a lot more labor intensive, a lot more documents, different type of analysis. It's a multi-factor analysis, so it requires you providing bank statements, assets, credit reports, your credit score, your employment history, transcripts, diplomas, and a list of any public benefits you may have received or applied for. So a lot of stuff. Your age goes into it, whether you're not health insurance. So thankfully, the 29th of July, a federal judge in New York blocked USCIS from enforcing this rule as long as we are considered to be in a national public health emergency, obviously due to COVID. The idea is that it's not fair to penalize immigrants for soliciting public benefits while we're all in a public health emergency, whereas normally you might not be doing stuff like that, but these are crazy times. And USCIS agreed with that. So they issued a statement shortly thereafter saying that they would comply with this injunction and not enforce the rule for any cases filed after July 29th or adjudicated after 29th, which is awesome because it means you don't have to go through that crazy analysis. You don't have to provide those documents. It's just a lot easier. However, unfortunately, in early August, the Second Circuit issued a decision kind of limiting that block, saying, no, USCIS still can request those documents. They can still do the public charge rule, except if you are in New York, Connecticut, or Vermont. So for the rest of the country, any other states, public charge rule should be the same. Just those 3 states, they're not allowed to enforce it in. However, USCIS hasn't really changed their politics on this yet, so it's still the webpage. If you go on their webpage, it still says they're going to comply with that 29th of July order. There's been a lot of decisions in the past, so late July to early August, there's tons of court decisions coming out on this. So it's likely that USCIS just doesn't know what they want to do yet, how they want to enforce it, to what extent, especially as it's more than likely we're going to see more litigation. So we're definitely recommending to our clients, since it is something we've seen, 1 week it's one thing, no, you can't enforce it. The next week, yes, it is. The next week, yes, it is, but only in these states. We're definitely recommending to our clients that they go ahead and get documents, because it's more than likely that stuff is going to change again. We're going to have more court decisions. And so we definitely want them to be prepared, and anybody to be prepared in the event that they need to present them. You don't want to be scrambling for this, these 200 pages worth of documents when you could already have them ready. So we do recommend, even though it's a pain, please go ahead and keep gathering those public charge documents, just because everything is changing so quickly. Moving on. talking about those planned furloughs. So originally the USCIS had planned to suspend about 13,000 of their employees. That's almost 3/4 of their workforce in the beginning of August if they didn't receive a $1.2 billion loan, bailout from Congress. Luckily, some state senators were able to, convince USCIS to put that on hold, to postpone that furlough until August 30th. However, they still haven't gotten that bailout, and August 30th is quickly approaching. So Congress, in theory, was planning on including that $1.2 billion bailout in its last coronavirus relief package bill, but that bill was not passed. Congress is now in recess, and it will be in recess until September 7th. So unless senators again can convince USCIS to again postpone that planned furloughs, more than likely August 30th coming up, we are going to see 3/4 of the USCIS workforce be furloughed for at least 30 days. If that happens, we can basically expect the immigration system to grind to a halt. They're only going to have 25% of their employees. It's going to be really difficult to process cases as normal. So just be prepared. If you are thinking about applying for a case now, or if you have already got a case in process and this furlough happens, those processing times that we always say can change and that are long already are probably going to get a whole lot longer. Now, also talking about USCIS and money, one of the reasons they say they need money is because during coronavirus, not a lot of people were submitting applications. If you don't have any discretionary income, maybe you're not going to go ahead and apply for that benefit that you've been thinking about applying for. So they say that because of that, they didn't get enough income to maintain their employees, and that is why they need the bailout. And how are they going to pay the Congress back for that $1.2 billion? They are going to raise their fees, and they did so. So these fees have been talked about since last year. There was a lot of revisions, and now they finally come out with this final rule, and it goes into effect October 2nd. So the fees, new fees, everything is changing October 2nd except for DACA. DACA cost stays the same, $4.95. Everything else has changed. There's a couple of things that have gone down, not extremely. Usually if it's gone down like $20, but most things have gone up. So I'm going to give you guys some examples of ones we've been seeing a lot. Just these are types of cases we see a lot in our office and that are increasing a lot. So citizenship currently $725. Starting October 2nd, that's going to go up to $1,170. That's $445 more. The idea is that they have basically maintained it artificially low, the cost. So the fees are based, quote unquote, on how much work it takes to process each type of form. So because citizenship is considered to be such an important thing, obviously, they have maintained that fee artificially low. However, they say if they were to continue to do that, then they would have to really increase all the other fees. So they are now adjusting it to reflect how much actual work it takes. And according to them, it takes $1,170 worth of work to process a citizenship form. Nevertheless, they're still increasing most everything else. So for example, green card application with a travel permit and a work permit included is going to be $2,270 now. That's an increase of $1,045. And if you add an immigrant visa petition to that, so that's something we see a lot, like marriage adjustment, you're married to a U.S. citizen, you're going to file everything as one package. The immigrant visa petition, your green card application, your work permit, and your travel permit, that's going to be $2,820 now, starting October 2nd. Right now, it's $1,760. That's over $1,000 of an increase. Removing conditions, if you're eligible to do so prior to October 2nd, I recommend you do it. Right now, it's $680. Starting October 2nd, it's going to be $760. And then finally, work permits for almost everything except, like I said, DACA. Currently, it's $410. If you need to renew or apply for one in the future, it's going to be $550. So, like we always say, if you're thinking about filing, do it. Now is a good time to do it. Now is the best time to do it because it's going to get more expensive. Obviously, we'll keep you updated on any changes regarding those fees. There shouldn't be any changes. The furloughs, whether or not they will or will not happen, and how those are going to affect your cases. Moving forward, we're just going to talk briefly about immigration court. Don't have much to say here. Just want to give you guys the latest. So Arlington, Virginia, which is the court that most of our cases are heard in, just because it is the closest court to us outside of Washington, D.C. It resumed all hearings starting on July 20th, 2020. So if you did have court during that closure period, that was from about mid-March to July 20th, if you had a court scheduled then and obviously it was canceled, it's going to be automatically reprogrammed, rescheduled. So make sure that the court has your current address so that you get that new notification. If you don't keep your court updated, they can't send your notices to the right place. If you don't know you have court and you miss it, you're going to get ordered deported in your absence, and that is disastrous. Some courts and other locations have reopened. If for some reason the court where you're supposed to have your hearing has not reopened, they have just kind of a flat blanket closure still for all non-detained hearings until and through September 4th. Basically every week they've just been extending it a week. So probably later today they'll come out and extend it to September 11th. We'll see. If you don't know where your court is, you don't know when your court is, you have no clue anything about it, but you do have some type of notice and you have your A number, which is that 9-digit number, starts with an A and then those 9 digits, you can call the court with their electronic system and they will tell you when your next court date is, what time and where. That number is 1-800-898-7180, 1-800-898-7180. And then finally, I just want to give you guys a couple of last two little tidbits. Let's say our local, quote unquote, ICE detention facility in Farmville, Virginia tested all of their inmates recently. Over 80% of them tested positive for COVID. They say most of them are asymptomatic. They've also had 2 deaths in the detention facility due to COVID. So they are allowing a third-party expert to come in and analyze, provide suggestions. So we're definitely keeping our fingers crossed for improvement. Obviously, we do not want people detained having that high rate of testing positive. So hopefully we'll have some improvement on that. And then finally, kind of some good news to end with is some information about the I-9 revalidation. I know we've been talking a lot about how there's been some delays in getting actual cards produced because USCIS switched to in-house production of cards. So if you applied for your work permit or you renewed your work permit and you got your approval notice, the piece of paper, the nice thick green paper, but you haven't gotten the actual card yet because of those delays, and your employer is asking that you revalidate your I-9, USCIS has just announced that you can use your approval notification together with your ID to revalidate. Your approval notice has to have a date of December 1st, 2019 through August 20th, 2020, so an approval date of between those time periods. But if you present that with your ID, you should be able to revalidate for now. Obviously, in the future, they're going to ask you to update again once you have your actual work permit. But for now, you don't have to stop working. You can revalidate. So that's some good news. If you guys have any questions, like I said, mine is always much quicker than John and Radlin's, my updates. If you guys have any questions, just feel free to comment below. Send us a message via Messenger. Email us at info@gmlaw.net. You can call us at 757-464-9224, or if you're in the peninsula, you can call us at 757-693-5532. Thank you for listening. Thank you for tuning in. I hope you all have a wonderful weekend, and please share this page, share this video if you guys think it will help any others. Next week, you'll be back with John and Radlin for your regular programming. Have a great weekend. Bye.